Mary Laura Anthony, founding partner of Anthony P. LLC, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about the SEC's recent public inquiry on earnings releases and quarterly reports. In addition to annual reports on Form 10-K and current reports on Form 8-K, companies subject to the periodic reporting requirements under the Exchange Act of 1934, other than foreign private issuers, must file quarterly reports on Form 10-Q, which include independent auditor-reviewed interim financial statements as well as other disclosure items. Foreign private issuers must file annual but not quarterly reports. These quarterly reports, as well as other periodic reports, may be forward incorporated by reference into Securities Act of 1933 registration statements, such as on Forms S1 and S3, reducing the need for duplication of this information through post-effective updates of those registration statements. As an aside, the FAST Act passed into law on December 4th, 2015, amended Form S1 to allow for forward incorporation by reference by smaller reporting companies, which category of company has recently been increased with the amended definition of a smaller reporting company. Other categories of filers, including accelerated and larger accelerated filers, were already allowed to forward incorporate by reference. A Form 10-Q is subject to the anti-fraud provisions of Sections 10b and 18 of the Exchange Act and Rule 10b-5, and can be a source of liability to the company, affiliates, and underwriters under Sections 11, 12, and 17 of the Securities Act related to the offer and sale of securities. Each of these provisions imposes liability on companies in certain instances for making any untrue statements of a material fact or admitting to state a material fact necessary in order to make the statements made, in light of all the circumstances under which they were made, not misleading. The difference in the sections relates to whether the cause of action is private or can be pursued by a regulator or governmental body. If private, who has the right to pursue the action? For example, Section 11 provides an action for any purchaser of securities, regardless of whether they bought directly from the company or secondarily in the aftermarket. The elements of proof may differ, such as scienter or intent or loss causation. Allowable damages may differ, the standard of proof may differ, and other of the elements of the causes. Liability under certain of the provisions, such as Sections 11 and 12 of the Securities Act and Section 18 of the Exchange Act, attach only to documents that are filed with the SEC or incorporated by reference into a Securities Act registration statement. A Form 10-Q is always deemed filed with the SEC and, as just mentioned, may be incorporated by reference into registration statements under the Securities Act. However, the SEC allows certain information to be furnished as opposed to filed, as long as the company specifically discloses that it is avowing itself of the ability to furnish and not file. For example, reports in a Form 8-K under Regulation FD and earnings press releases under Item 2.02 of Form 8-K related to the results of operations and financial condition of the company are allowed to be furnished and not filed. Although liability under Section 10b and Rule 10b-5 of the Exchange Act may attach to documents that are furnished, the standard of proof and elements of a cause of action are different under those rules and harder to prove. As mentioned, foreign private issuers must file annual but not quarterly reports. However, a foreign private issuer has an obligation to furnish certain information on a Form 6-K, which is like an 8-K, including, for example, information it makes or is required to make public pursuant to the laws of the jurisdiction of its domicile or in which it is incorporated or organized, or files or is required to file with the stock exchange on which its securities are traded and which are made public by that exchange, or distributes or is required to distribute to its security holders. This information is subject to liability under Sections 10b and Rule 10b-5 of the Exchange Act and if incorporated into a registration statement, become filed in that registration statement and subject to liability under sections 11, 12, and 17 of the Securities Act. As a result of these requirements, reports on Form 6K often include quarterly reports and quarterly financial statements. For example, Canada, Hong Kong, and Japan all require quarterly reporting, and thus those reports would be filed with the SEC on a Form 6K. On the other hand, in 2013, the European Union, or the EU, amended its reporting requirements to eliminate the requirement to file quarterly reports altogether, which even prior to that time did not include financial statements anyway. The EU found that quarterly reports were a burden for small and medium-sized companies, didn't add to investor protections at all, encouraged a focus on short-term performance, and discouraged long-term investments. Companies may still voluntarily file quarterly reports, but most don't. I'm securities attorney Laura Anthony, founding partner of Anthony P. LLC and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.